Good afternoon, and thank you for spending part of your lunch with me. I appreciate that. All right, my name is Xena Robinson. I'm the owner and principal attorney of Mahanium Law, and that's where I help employers navigate difficult employee issues before they become expensive legal problems. So, if you joined me in the last webinar that was titled, Can I Terminate This Employee? You would know that there are a couple of things that we're going to talk about today that were mentioned in that previous training, but all of it is going to be relevant to what we're doing today. So it's almost like just a continuation of what we talked about last time. Okay. And so one thing also I want to make sure that we touch upon today is briefly in the last webinar, we talked about discipline and termination. But really, the reality is a lot of terminations and a lot of litigation doesn't exactly start from termination, doesn't begin with termination. They usually begin with an employee complaint, right? That maybe wasn't handled correctly, right? Not all litigation is the reason for that, but we see that there is a majority that is following under that context. All right, so which is why today's presentation is really going to just touch upon, in those first few hours when someone raises a concern, what happens? What is the employer's obligation in those first few moments when an employee raises a concern, right? So maybe it's harassment, or maybe it's discrimination or retaliation, or maybe it's just an employee saying, this thing happened to me. I don't think it's fair, right? So whatever it is, how you respond in those first few hours often determines whether you are solving a workplace issue or whether you're creating legal exposure for your organization. All right. So, my goal today is pretty simple. By the end of the presentation, I want everyone here, to leave with a practical framework that you can use the next time an employee walks into your office or, sends you an email that immediately makes your stomach drop. Okay, so that's the goal for today. But before we begin, I do have a quick disclaimer, right? So this information presented today, it is for educational purposes only. It is not legal advice. So every situation is unique, and attending this webinar does not create an attorney-client privilege or relationship or anything along those lines. All right? All right, just wanted to get that out of the way. In all my webinars, I always make sure to just drop that quick disclaimer. But as we go through this, feel free to ask any questions that come up. If there's anything that I touch upon that you're wondering about, there is a Q&A box that you should have access to. And you could just throw it in there. I believe I hope I clicked the feature before I started the webinar, but you should have access to that. So throughout the webinar, any questions, just throw it on in there, okay? All right, so let's get started. All right, so I have a quick scenario for you. All right, so let's say, it's Monday morning, you're sitting down, you have your cup of coffee, all right, you open Outlook, scrolling through your emails, and at the top of your inbox, all of a sudden, is an email, and the subject line says, I need to report harassment, right? Now what? What do you do now? What's your first move, right? And I leave that because this is something, it may not happen often, right? But there are employers who do get emails like this quite often, right? And it never changes how you feel. It's always a nerve-wracking experience because it's something that should be taken seriously, right? So again, I ask, what do you do? What's your first move? All right, so do you call HR? Do you call an attorney? Do you call me? Right? Do you run and, go interview the person that was accused of doing something wrong or of doing the harassment? Do you, send somebody home, maybe put them on admin leave? Do you say, promise confidentiality? And you're like, I promise I'm not going to tell anyone. It's going to just be between the two of us, right? Or, do you figure, what, this is just a lot right now. It's just really overwhelming. I'm going to deal with this tomorrow or maybe the next day. I have a bunch of meetings today. I have all these emails. Let me just get through my work day and I'll deal with this at another time. Right. And I'm sure that some of you have probably lived that exact moment, and maybe not like the harassment part of it, but I'm sure you've at least received a complaint that immediately made you nervous. All right. That's just if you own a business, if you have employees, you're going to have those complaints that are going to just make you nervous. Okay. But the good news about that is, receiving a complaint from an employee, it doesn't mean that your organization is broken. All right. Healthy organizations receive complaints quite a bit. Right. It just shows that employees are actually comfortable enough to speak up and give feedback. Right. An organization where employees don't speak at all, that's concerning, especially when there are issues. Then you should be concerned. But if your employees are, feel confident enough or feel safe enough to come and complain about something or come and tell you something, then, that's a good sign, right? And but in those moments, the real question really isn't, whether the complaint is going to happen, right? Because you will receive complaints, right? The question that I really want you to hone in on is, whether your organization knows what to do next. So when you get that complaint, what do you do? What's your process? What does that look like in your organization today? Do you even have a process? If someone was to complain right now, who should they go to? Do they go to John next door? Do you have an HR department? If you do have an HR department, is there a point person for complaints? What's that process look like? And that's what we want to make sure that we're touching upon, right? Because that's where employers often get in trouble, right? Where the process is lacking at the point where response is needed. All right. So, one of the biggest misconceptions that I actually see in this work is that, employers think that the complaint itself is where liability is created. And that's actually not true. Right. So, most of the time it isn't. It actually is the response, like I just meant, as we just discussed, but it's really the response part that creates that liability. And I really want to hammer this home because it's definitely something that a lot of employers have to unlearn and relearn. And the best way to unlearn and to relearn something is to hear it over and over, be consistent in hearing it, make it repetitive. And so we want to make sure that it is hammered in, that it is the response. How you respond to an issue is what creates liability. I've represented, and advised employers for years, right? And I can honestly tell you that, I rarely meet an employer who wakes up and they're like, I want to violate some employment laws today. I feel like hurting my employees and I feel like, stepping on their rights or whatever the case may be. I want harassment to happen. I've never, ever come across an employer of that nature. If anything, most of the employers that I work with are actually pretty great. They want their employees to succeed. They actually care about their employees. They want the organization to do the right thing. I haven't had any employer yet, thank God. I haven't had an employer yet that just wanted to, run rogue and break the law, right? But one issue is that no one really ever taught them what to do after a complaint. So we see a lot of these, lawsuits coming out, or a lot of these complaints happening, or these legal claims happening. And it's not because the employer wanted to do wrong, it's that they just didn't understand what their obligations were. Right. So like I said, the problem really is about poor response. And poor response does lead to retaliation, right? Poor response does lead to failure to investigate. If you put something off for too long, right? It's easy to say, oh, you failed to investigate this properly, right? It leads to discrimination. Oh, well, when this person complained, you handled it pretty quickly. Every time I complain, you never take my complaint seriously. Is it because I'm a woman? All the other men, when they all complain, you run to their rescue. But, anytime I bring an issue to you, you could care less, right? That's the start. That could easily be a start of a discrimination complaint, right? Loss of trust. Every time I bring a complaint to you, you never address it. So now I know I'm never bringing a complaint forward. If anything happens, I know that you're never going to handle it. I'm not bringing it forward, right? Litigation. If you handle a response incorrectly, it will more than likely eventually lead to litigation if the employee pursues it, right? So, and a lot of the time when I see that there is poor response happening from an employer, usually it's, maybe someone panicked, they didn't know what to do, so they just kind of typed whatever they thought in the moment, and then just acted too quickly. They didn't take time to just sit and think through the situation first, and sometimes it's more they just wanted to try to make the matter disappear. So they did whatever they could to try to make it go away, not knowing that they were making it worse and putting the organization in even more liability. Right. So today I have just a simple process for you that you can use. It's easy to remember, and you can use this framework anytime you're looking through an employee complaint. You can use this framework and do the complaint, and process the complaint on your own, or whoever in your organization is in charge of handling that. All right. So the framework today is the response framework. And I know every training I have some type of framework, but honestly, for me, acronyms work. I remember them. And so I assume if it works for me, it's going to probably work for a lot of other people. So every time I do a webinar, I try to, sit down and think through, what acronym would make sense so that it's simple enough for people to go home and do it in their own time, or incorporate it into their own organizations, right? And I say this framework because maybe when there's an employment law training happening, maybe there's the expectation that there should be statutes, or I should be going through a bunch of legal doctrine or a bunch of different case law or reading legal jargon to you. But honestly, I don't find that that's helpful. And I find that, you still leave with the question of, okay, so what do I do if the complaint comes? Well, thank you for updating me on what the law says, but if a complaint comes, what now? Right? So it's not so helpful just to throw the law at you, which is why I find that just showing you how to apply the law instead is more effective. Anywho, so you might hear me through this presentation. I might be saying the word respond over and over again. More than likely, that's really just to make sure that it's not only being hammered home, but that it's resonating with you throughout the presentation. And honestly, after you leave here today, you might get a complaint and then you remember, oh my gosh, yeah, respond. Okay, this is what I need to do. Right. And at least now you have the basics of what needs to happen when you're going through an employee complaint. Okay. So respond. All right. So really created this framework because also sometimes it can just be overwhelming to deal with complaints, right? But honestly, if you can remember these 7 and you can screenshot it, whatever you need to do for later. I'm also gonna throughout the slides, I'll be elaborating on each one. So feel free to take screenshots if you want. If you want the slides afterwards, you can email me and I'm be more than happy to send the slides to you. I don't care. I'll make sure you have them if you need them. But yeah, I'm going to just walk through each of these. So respond, R is for receive, E is for evaluate, S is for secure, P for protect, O for organize, N for navigate, and D for document. All right. So, you don't have to memorize employment law, right? But you probably should memorize respond, right? Because in reality, all you really need is a consistent process, right? So as long as you can at least memorize and understand what the proper process is for your organization, that's what's going to help you be successful when you're tackling these employee complaints as they come in. Okay. All right. So let's start with R. All right. And honestly, the first conversation really matters more than a lot of people think. That first conversation is very, very, very important. Okay. Employees, they often decide within that first conversation whether they're going to trust your process or not, or whether they feel like you're being genuine, or whether they feel like you even care about what happened to them. All right. So, once the complaint comes in, obviously what's expected of you is be professional about it, handle it professionally, receive it professionally, right? So what you want to do is listen. Maybe they came into your office and sat down and, just told you everything that was going on, all the complaints, whatever the case may be, whatever they complained about, right? First and foremost, you want to just listen. Don't try to add your 2 cents. Don't try to, make it story time for the both of you. Just listen, right? Take notes, right? But stay calm. Make sure you remain calm. Even if it's a crazy situation, there's already enough chaos. They don't need their manager or their leader to be chaotic with them as well. Someone has to be cool-headed, right? And that should always be you. Okay. And as you remain calm, once they're done, Once you're done taking your notes, you thank them. Not so much, you're not thanking them because you agree with what they're saying, but you're more so saying, thank you for bringing this forward, right? Because you want them to know that it is okay to bring complaints forward. You want them to feel comfortable knowing that, okay, when I bring my complaints forward, I know that they're actually being heard. And most times, employees, most of the time, they don't even really want, someone to get in trouble per se, depending on what happened. A lot of the time, they just want to feel heard and they want to know that they're being looked after, right? Or they just want whatever's happening to stop. They don't want someone to get fired a lot of the time, depending on the severity of the situation. But most times, they just want someone to hear them and to make whatever's happening stop. Right. So you thank them. Thanks so much for bringing this forward. I appreciate you, trusting us enough to come forward and let us know this. And then you explain the next steps. Just let them know I'm going to look into this. I'm going to make sure to do my due diligence and, I will be in touch with you. Just give me some time to evaluate this properly and I'll follow up with you within the next 2 weeks or something along those lines, right? And even sometimes employee, like if it's something that you actually realize warrants investigation, investigations can sometimes take a bit, especially if there's a lot of moving parties, if there's a lot of information to look through, if there's different facts that you have to consider. So saying 2 weeks doesn't mean that it's going to be done in 2 weeks, right? But you do owe them a follow-up in 2 weeks. You should be reaching out to them to let them know what's going on, right? Because a lot of the time employees sit there and they think that, well, if I haven't heard from you, that means you're not moving. If I haven't heard from you, that means you're not working on my issue. You don't care, right? But if you're constantly reaching out to them and letting them know, like, hey, we're still working on it, we're still investigating, but just wanted to reach out to see how you were doing. If you had any questions, here's the employee assistance program. If you weren't aware of it, I just wanted to make sure you had this information so you can look through to see if there's any resources that would be useful to you that the company provides, right? Just checking in with them once in a while, just so they know that you're actually working on their matter, right? And what you don't want to do, right? You don't want to promise them that you're not going to tell anybody because you are going to tell someone, right? Obviously, it'll be those who need to know, right? It's not like you're going to go around and start telling the whole organization, like, oh, this person just complained about harassment, right? But where investigations are concerned, you can't keep it to yourself. You have an obligation to investigate what happened. You have an obligation to bring in all the necessary parties to get all the necessary facts to come to a conclusion. You can't come to a conclusion without all the facts, right? And let's say this does become, a larger issue or something along those lines. You're gonna have to say something, right? So you can't promise confidentiality, right? But you can promise that you will keep it between those who actually need to know. That you can do. Don't promise discipline. Don't, after they're done, stating their complaints, don't then say, "Oh yeah, we're gonna get them. Oh yeah, they're done here. We're gonna fire them. Oh, I'm gonna get them. They're in trouble." Don't do that because you don't even know what happened, right? You heard their side of the story, but if I've learned anything at all from my years of employment law, there is three sides to every story. There is what happened, what didn't happen, and what actually happened, right? Somewhere along those lines, you piece the stories together. There's going to be inconsistencies. There's going to be this person's perception, that person's perception. At the end of the day, what stories we're hearing is everybody's perception of what they think happened. But when you look at whatever evidence is in front of you, a lot of the time, that's what's actually going to tell you the story, especially when you hear from witnesses and watch maybe video footage if that's available, right? That's what's going to actually be able to tell you what really happened in this situation. Okay. So don't just take someone's word for it. Don't take sides. I've had situations where, actually most recently a manager was like, I know them. This is typical. This, I'm sure they did it. I'm sure they did it. Okay. But first of all, you weren't even there. So you can't just jump to a conclusion when you weren't even present, right? And you haven't even asked the witnesses. You haven't asked for any witnesses. You haven't looked at it for any evidence. You heard a complaint and you automatically chose a side and you automatically jumped to conclusions. So now what happens when we investigate and we look at the issue and we determine that the employee actually didn't do anything wrong and that they were completely innocent? What then? What do we do then? You've already accused them, right? Probably already disciplined them or made them feel like they have done something wrong, right? So that's why we don't jump to conclusions, because what if the findings, what if there's no findings? What if you are unable to substantiate? What do you do then, right? And don't minimize their concerns. A lot of times an employee will bring a complaint forward and it might feel, maybe it might feel basic, or sometimes it might feel like it's not that serious, but it was serious enough for them to bring it forward, which means that it's something that they actually care about, right? So we want to make sure that we're treating every complaint seriously and we're letting the employee know that their complaints matter and that we will be looking into it and we'll get back to them once we've looked into the matter and done our due diligence. Okay, so that's what we want to make sure we're doing. And then also, oh my gosh, I've had situations where in meetings with these employees, managers have said some concerning things. So if you're ever in a meeting with an employee, please don't say anything like, I'm sure he didn't mean to do it, or I'm sure she didn't mean to say that, or, you know, I, I know her, she would never do that, or yeah, we're going to just keep this between us, Don't say stuff like that, because what that does is it just creates an even bigger problem for you, right? Those are statements that can be used against you, right? So, which is why I'm just like, keep the meeting simple. Just listen to what they have to say. Don't add your 2 cents. Take the notes that you need. If they have any email evidence or anything that they'd like to send you to back up their complaint, great. Yes, please send it over to me. I would appreciate that, right? Take your notes, thank them for the report, let them know that you will look into the matter and that you will follow up with them, end the meeting. Don't make it a long story time, because eventually something's going to be said that you're going to regret. So keep it simple. Keep it simple. Okay. All right. There was recently, there was a matter that came out. And I want to bring this up just simply because I've seen instances where there might be like the star employee, right? Everybody loves them. They can do no wrong in anybody's eyes, right? They're the best workers, right? If you lose them, it's like a horrible detriment to the company, right? And I've recently had a matter where the star employee was reported, right? There were policy violations, right? But the thing is, in this particular instance, I find that sometimes employers feel that pressure to not take the complaint so seriously or try to make it go away because, oh, well, this is our star employee. We don't want to lose them, right? You may not want to lose them, but if you don't handle that complaint correctly, you're going to lose them anyway, and you're going to pay for it, right? So the way you treat complaints, it shouldn't matter, if it's the star employee or the new employee or the employee you don't like, right? Because we know that there are people who have those. Let's be honest, right? We want to make sure that every single complaint that comes through that door is treated exactly the same. And with that employee, what ended up happening, so we investigated it, right? As opposed to in-house investigation. There are instances where it's just more appropriate to get outside investigators to come in as opposed to doing it yourself, to avoid any issues with bias or anything along those lines. Especially if you have a close relationship with someone, you should always make sure to pass it off to someone who can investigate without bias. Okay. All right. So next in the chain, we have evaluate. All right. So we know that not every complaint is the same, right? So there are different kinds of complaints that you may come across, right? So you may have, it might be a conflict between two employees. Maybe they just can't get along. They hate each other, close to pulling each other's hair, right? Or close to fighting, whatever the case may be. Or he said this about me, or she said this about me, or, happens all the time, right? A lot of workplaces is almost like high school at sometimes, but it's the name of the game. It happens everywhere. All organizations are going through that right now. Policy issues might come up in a complaint, right? You may have a legal issue that comes up or an emergency that comes up. So let's get a little bit deeper into that. So let's start with employee conflict, right? So what an employee conflict might look like, right? Are your day-to-day interpersonal issues. So like I said, personality clashes, communication breakdowns. Maybe you have a disagreement over like workload or something like that, or maybe they just don't get along for some reason, right? So those situations can certainly affect morale and productivity in the workplace, especially if it's just getting too much, right? And they don't automatically involve legal issues, but you know, those type of situations still should be resolved, whether it's through coaching or mediation or just having some type of a conversation with the employees, right? And then reminding them about professionalism in the workplace. If it's something to where it's more of a coaching or mediation that needs to happen, reminding them professionalism in the workplace, we don't condone, certain language or certain, acts. And if this happens again, or, if it becomes to a certain extent, let them know that we may have to move forward with some form of discipline if this continues, right? Because at the end of the day, you want to keep, an orderly workplace. And if they're causing disorganization, if they're behaving in an unprofessional manner, using profane language, getting physical, especially physical, that's where, there should be a zero tolerance for that, right? So, with the second category of policy issue, right? So these complaints, they involve violations of the organization rules and expectations. So, for example, maybe an attendance problem, or there's a dress code violation, or maybe a misuse of company equipment, timekeeping concerns, or maybe any other conduct that doesn't necessarily violate the law, but it might violate company policy, right? So those situations are typically addressed through, the normal performance management track or the disciplinary process, right? So that's how you would look at the two. So either it's a performance issue with their work product, or it's a discipline, a misconduct type of issue, right? And there's some sort of a violation there. All right. So now with legal issue, right? So this is where employers have to slow down. And if you were in my last webinar, this is where, especially where the pause framework is going to come in, right? And if you weren't in the previous webinar, you can check out the replay. It is on YouTube. I can always send you the link for that. But we went through the pause framework, which goes through, what to do in pretty much a situation like this, right? So you want to pause and think through the issue, right? So a legal issue, it might include maybe, harassment, discrimination, retaliation, wage and hour concerns, maybe leave laws like PFMLA or FMLA, right? Disability accommodations under ADA, or some type of a request for a religious accommodation, right? So those type of complaints, they might trigger legal obligations, right? And those often require a more formal response, not just a little quick conversation. With those type of things, you need to make sure your documentation is on point. You don't have room for error, which is why you might as well just have a process you use consistently every single time. So you don't have to, so your process stays consistent across the board. Okay. And then finally, for emergencies, if there's a complaint that involves maybe threats of violence, physical altercations, a weapon, serious safety concerns, maybe like a medical emergency or something like that. In that moment, your priority isn't to conduct interviews, right? Your priority is to protect the people. Safety comes first, always, right? So once everyone is safe, then you can begin your investigation. Okay, what happened? Okay, we got to talk to those who are involved and figure out, next steps. What's going on? Is there footage available? Are there witnesses available? That happens after you know that everybody is safe and everything has been taken care of. All right. So, and it's also important to remember that, complaints don't always fit neatly in just one of these categories, right? So, for example, two employees may be arguing over like a workplace assignment, right? And, it might be just a simple employee conflict. But what if one of those employees says, they're being treated differently because of their race or because of their gender or maybe their disability, right? So now, if that comes up, we're looking at a legal issue. So what was once just a simple employee complaint or an employee conflict, I mean, is now a legal issue, right? And so if the argument escalates into a threat of violence now, and it becomes an emergency, right? So you see how you can be in one category, more than one category at a time, right? So it's definitely important to evaluate the complaint carefully before deciding how to respond. All right. So next we are hopping over to secure. All right. So a mistake that I constantly see is that employers tend to wait and they think like, oh, I'll collect whatever evidence or information I need next week, right? But what if it's not available next week? What if you go looking for it and it's not there, right? What if it's just no longer available? Or they can't find it anymore. Or I deleted it. Oh, I didn't know you needed, I deleted it by accident. Whatever the excuse is, right? Or, oh yeah, I think I threw it away. I don't have the paper anymore. It's in the trash, or I discarded it, or something like that. So as soon as you get the complaint, what you want to do is make sure whatever information you're going to need, write that down, especially if the employee already gives you what they have available, have them just send it to you immediately so that you have it. And then take note of everything you're going to need and just reach out to the necessary parties to get the information. Don't wait until next week because it might not be available next week. All right. So I'm talking like, Teams and Slacks and text messages, security footage, right? Sometimes security footage can automatically get overwritten, right? There are times where that has happened, right? There are organizations, more larger organizations, where they do, it's probably easier over there because they're able to save that footage, right? But there are organizations where it's just not available, only like it expires after a certain amount of time, right? Especially if the employee is bringing the complaint pretty late. Sometimes employees don't complain immediately. Sometimes they wait because either they're scared to come forward or maybe in that moment they just weren't ready to tell you. They're not obligated to tell you immediately when something happens, right? Sometimes they want time to sit and process it. So let's say someone brings you a complaint a month later to say, hey, last month this thing happened to me. And what if the information you need is, so you want to just make sure that once a complaint comes in, you do your due diligence to get the information you're going to need. All right. Because like I said, I've seen text messages deleted. So just always preserve what you need first and then analyze it later. As long as you have it, you save it in a folder, put it where you need to put it so that when you're ready to get to it, you have it. All right. All right. I wanted to make sure I hammered that home because I've been through situations where it could have been available, but it wasn't, and now we're toast, right? So protect. So, retaliation. I discussed retaliation at length in the previous webinar, but it is such an important topic that anytime it comes across, I do need to still hone in on this particular topic. Retaliation is really one of the fastest growing employee complaints out there right now, and one of the most common ones that I see. And many employers think that retaliation only means maybe firing someone after they complained, but it is so much more broader than that. Something small can easily become retaliation unintentionally. So, and it's, I guess for those who weren't there last time, retaliation is basically any materially adverse action taken because an employee, maybe they engaged in protected activity. So maybe they reported discrimination, or they reported harassment, or they reported maybe another legal concern, or maybe they brought up a safety issue or something along those lines, or maybe they complained about their manager harassing them or doing something to them, and next thing you know, they're being treated differently, right? So what's important, what we want to understand is that most retaliation is not intentional. It's usually reactive. It's usually a manager or a supervisor or someone reacting to something that has happened, right? So that's how we see it usually happening. And usually it's because maybe a manager is becoming frustrated, or maybe they've lost trust in that employee, right? So, and the employee may very well be justified in that they're being retaliated against. And, you know, the managers are people too, right? So they might be just frustrated and just they no longer trust the employee, or they don't mean to treat them differently, but subconsciously they start to do that, right? And a lot of times we might see, after maybe some sort of a protected activity, shortly after that, we may see that there's a change in the employee schedule, or maybe they were removed from an important project, or they start getting left out of meetings, or now their work is being micromanaged, right? We start seeing little changes like that, right? And even in those decisions, maybe it was done out of good intentions. Maybe they were removed from the meeting because their part of the project was done. So the manager was like, oh, well, I'm going to give you your time back. You don't have to come to these meetings anymore. Use the time to do something more productive, right? Or maybe there was a change in schedule because maybe the manager was like, oh, yeah, I remember they said that this time isn't so good for them anymore, and this just opened up. Okay, let me just put them in there, right? And maybe whatever change happened had nothing to do with the complaint, right? But you still want to look at the issue in totality, right? Because it can still create legal risk if it occurs because the employee spoke up. And if you can't prove that you did the act out separate from the employee complaint, if you can't prove it, you're going to still be held to it, right? So you're going to need to prove that whatever act or whatever conduct is being seen as retaliatory was actually for legitimate business reasons, right? Which is why it's important to document everything, because if you can't prove that you changed their schedule for a legitimate business reason, or you remove them from the meeting for a legitimate business reason, then the assumption is that they were being retaliated against, right? So that's why I encourage employers to, ask yourself one simple question before making any employment decisions that involve a complaining employee. All right. Ask yourself, would I make the same decision if this employee never made a complaint? All right. If you know that you would have done something completely different if the employee never complained, don't do what you're about to do. All right. If you can't answer yes to that confidently, if you can't say, yes, I would still make this decision even if the employee didn't complain, if you can't say yes to that, or if you're unsure, right, you definitely want to pause. You want to document your reasoning, and you want to seek proper legal guidance, right? Whether you have in-house counsel, or maybe, you have an employment attorney that you go to, you have my information. It's a 5-minute conversation is better than 5 years of litigation. At least to me. I don't know about you, but to me, it just makes sense to have a quick conversation before pulling such a trigger than ending up in expensive long-term litigation. All right. So that was P. All right. So I want to just go through this one case with you guys real quick. This is City of New Inn versus Commonwealth Employment Relations Board. And I'm not going to go through the entire case here, because I'm looking at the time and I'm seeing that we're definitely running short on time. So I'll try to breeze through it as much as I can. But if an employee received a raise, if you gave your employee a raise, is that retaliation, right? And many people, and depending on the circumstance, of course, but generally the answer is no. Of course, that's not retaliation. They're going to be happy with that raise, right? But in this particular case, what happened was it was determined to be retaliation, not so much the raise, right? Because the employer tried to say that giving this employee a raise shows that they weren't retaliating against the employee. I'll give you a little bit of backstory. So there is this union representative. He was always raising complaints and he was, fighting for their rights and all the things. And they found him to be quite annoying, right? Um, so one of the managers or supervisor leadership that he would constantly get in back and forth tidbits with, it got to a point where they changed his shift to the night shift. And once they changed his shift to the night shift, he's automatically he's going to get differential, right? He's going to get evening shift pay, which he's going to get an increase in pay anyway, right? So the employer argued that, well, yeah, we changed his schedule, but he's getting a raise. It's a better position, right? But why court saw that this was retaliatory was because it disfavored the employee, right? It brought a burden onto the employee. It wasn't helpful for him at all. He didn't want to work the evening shift. He didn't want that shift, right? They put him there to obviously like get him out the way because he was being annoying and they were tired of him complaining and all the things. But it wasn't a reward. It was a punishment, right? And so yeah, he got a raise, but it wasn't one that he wanted, and he was obligated to receive that for being on the evening shift, right? So if you move an employee or like we mentioned before, and you change an employee shift after protected activity, and mind you, in this, there was protected activity, right? He was bringing up issues, union issues that were happening, right? Violations of the contract that the employer, that was happening with the employer, right? So that's all protected activity, and it was going on for a very long time, right? So there was a major change in his schedule, and that's just not enough. You just can't do that. Long story short, they had to pay up. All right, so let's move on to the next. But if you're interested in reading that case, you can you can look that up. It's City of New Inn versus Commonwealth Employment Relations Board. All right, so moving on, we're almost towards the end. So organize, all right? When it comes to employee complaints, not everybody needs to know everything. You don't have to tell, the whole staff and the whole office and all of leadership and all the things. There are going to be people who are the need to know people. And if anything, the more people you talk to, the more legal risk you're actually creating, right? Because now it's going to turn into rumors and it just never ends well. All right, so we want to keep it at a need to know basis, right? So obviously, when you receive a complaint, your first point of contact is your HR representative, right? If you don't have an HR representative, if you double as the office manager and the HR, well, they came to the right place, right? So then from there, who do you reach out to, right? Do you talk to your legal representative? Do you speak to leadership, right? If it's a HIPAA issue, do you talk to the privacy team? If there was some type of a breach or some type of a fraud happening or whatever the case may be, do you talk to the IT team? Do you talk to security if there's an emergency happening? Or is it so close to home that you need to bring an outside investigator to just handle the thing, right? So you want to know, you want to go through the motions of, okay, who actually needs to know? Whoever doesn't need to know doesn't need to be involved. The less people involved, the better. All right. Navigate. So one of the questions that I most often hear, right, is, do I actually need to investigate this? Is it really that serious that I need to do like a whole investigation on it, right? But the thing is, if you're dealing with harassment or discrimination, retaliation, threats of violence, fraud, any type of legal right type of thing, the answer is almost always yes. Almost always yes. Yeah, there are some things where you don't have to do a full-on investigation, but you should document it, right? There are some things that end up just being a conversation or like a quick coaching, right? But you still want to make sure that you've documented it. You don't ever want a situation where it comes up later and you have no dates of when you met with this employee. You have no emails of showing anything, any follow-up, nothing. Maybe an employee came to you and complained, and somewhere in the conversation they mentioned maybe something about their health, right? And now they're coming back, and maybe you told them, oh, I'm so sorry that you're not feeling well. Reach out to, go to employee health, and let's get you, maybe if you want to look into FMLA, we can walk through how to do that, right? And the employee's like, oh no, I don't want to do that, I'm fine. And then a couple months later, you get a complaint saying that, you didn't offer them FMLA or something like that, right? Or you discriminated against them because of their disability or because of their health or whatever the case may be. If you had just put it in an email where you offered them FMLA and you offered them employee assistance and you offered them support, you would be able to say, well, hold up a second. When this employee came to me, I did care. I did show concern. I told them, I gave them all the steps that they needed to follow. And I showed them what resources were available to them, right? That's what you want to be able to show to a jury, right? But if you don't have that email and if it was just a conversation, well, unfortunately in court, yeah, they'll let you say, what you need to say in court. They'll let you make your statements, but there's nothing stronger than documentation. Nothing. All right. So this is a quick flow chart that I created, and you can screenshot that if you'd like. And it just walks through when you're going through an investigation, just the quick steps to take. If you're not sure, or maybe you've never even done an investigation, right? But the first thing is once the complaint comes in, after you have the conversation, as we talked about, you're going to do your initial assessment of the complaint, all right? Whatever evidence you're able to gather, you're going to go ahead and gather that. Right? If there were any other names involved, any witnesses brought up, you're going to talk to all your witnesses. You're going to talk to all the necessary parties. You're going to talk to the complainant. You're going to talk to the, whoever was complained about. You're going to, once you look through all the information, all the facts, all the evidence, you're going to issue your findings. Okay. When you issue your findings, that's just pretty much stating, after I looked through all of this, I'm able to substantiate that, yes, there was a policy violation. After looking through all the facts, unfortunately, I was not able to substantiate that there was a violation. Or after looking through all the facts, it's more likely than not, or it's more likely that this did occur, right? You want to make sure that you're able to put that in your findings, right? If any corrective action is needed, maybe because of a policy violation or what have you, you're going to go ahead and issue that. And then once you're done, you're going to follow up. Just say, hey, like, I looked into your matter. You're not going to tell them the details of it, right? But they're not entitled to that. They're not entitled to know what happened to the other person if discipline was issued. They're not entitled to that. A lot of times, obviously, they want to know, like, oh my gosh, like, did they get a final warning? They're not entitled to that information. You keep that meeting short, let them know, hey, we looked into your concerns. We did our due diligence, we investigated, and we were able to, conclude the matter. I just wanted to follow up with you to let you know that it's been resolved. And, if you ever have any further questions or anything along those lines, feel free to reach out. But thank you so much for bringing your concerns forward. Short, sweet, to the point. If they do have any questions in that moment, feel free to answer them. But anything related to like the details of, the case, the details of the discipline, I would keep that off limits because they're not entitled to that. The same way they wouldn't want, someone bringing up their issues as well. That's not, although it involves something that they complained about, they're not entitled to that information. All right. So D, we're almost to the finish line, guys. We're almost there. All right, so for documentation, so you definitely want to be able to, show examples. And I think, we've already kind of been talking about this through the training, right? So one sentence of poor documentation can easily become Exhibit A in the courtroom, right? Imagine putting something in an email, like, oh my gosh, this person's so dramatic, right? And maybe it was in the context of they asked for a reasonable accommodation because they needed to go get medical appointments or something like that. Or maybe they can't stand for too long because their knees hurt. And the next email is, oh my gosh, this employee is so dramatic. And they bring a claim against you for disability discrimination. That type of email is gold. I would want that email. I would want that case, if anything, right? So, if anything, instead of as you're documenting, instead of writing, if you don't write how you feel, just write what happened in the moment. So, for instance, if the employee is in there and they're going haywire and they're just so flustered and all the things, don't say, oh, well, this person is being so dramatic or whatever the case. When you're writing your documentation, it could easily be, oh, this employee, became visibly upset during our meeting. They raised their voice. After stating their complaint, they stated that XYZ happened. Meeting adjourned at 2:15. Like, and we'll have I'll do another training to get more deeper into how to properly document. That'll be later. This wouldn't have had enough time to be able to do that. But in that type of documentation, you don't want to put too much of your feelings and your opinions in that. You're literally just stating the facts, just stating in your documentation what occurred. And that's it. Okay. No conclusions, no opinions, none of that. Okay. So like I said, you want to be objective, you want your facts, you want your dates, any witnesses, what actions did you take? Did you follow up with them? This is not the time to get emotional, make assumptions, put labels on people, speculate, or anything like that. Okay. All right. So here are 5 ways that employers create lawsuits. All right. So, like I mentioned before, in the first few hours, honestly, the first 24 hours is very important. You want to make sure that you do respond. Even if it's not that you have to use the 24 hours to actually, go do all the investigation and look into the matter, but you do want to at least respond to the employee. If it's an email, you want to at least respond to the employee and say, thank you so much for bringing this forward. I appreciate you, trusting us with this information. I'm going to, do my due diligence. I would love to sit down with you to discuss this further. When are you available to meet? Or I'm going to set time on our calendars so that we can both sit down and discuss this further, right? At least you've responded. You didn't just leave them on red. And that also shows that, one, you're reading their complaint and you're going to look into the complaint, like a pre-review of the complaint. And then you're going to follow up with them formally to dig deeper into the complaint and ask whatever questions you need to understand what happened even further. All right. So like I said before, taking sides, that's a big no-no. Don't take any sides, even if it's your friend or an employee you love so much. Be neutral until you know exactly what happened. Don't take any sides. Don't promise that you're not going to tell anyone. Don't promise confidentiality because you don't have the right to promise them that. All right. Don't ignore retaliation. If you're noticing maybe any behaviors or anything that's happening that could constitute retaliation, interfere immediately. Interject and handle that immediately. You want to make sure that there's no cause for some type of retaliation claim. And then finally, just poor documentation, not taking the time to sit down and make sure that what's happening is documented somewhere. Right? But there is a proper way to do documentation. This doesn't mean, go write a novel about everything happening, right? There's a proper way to document. And we'll get into that training maybe next time. Maybe the next webinar will be on documentation. All right. So hopefully some of these things aren't what you're going through, but if it is, at least now you know what to avoid for the next time. All right. So when is it appropriate for you to call an employment attorney? All right. So, even if you don't call an employment attorney immediately, or if you call an employment attorney, it doesn't mean that you're admitting that you've done something wrong, right? It's just often it's the least expensive decision you could make, right? Would you rather consult someone who can give you sound advice, or would you rather wait until you're in the courtroom to get that advice, right? It's up to you. But I would recommend that, don't wait until the problem explodes before you get help. It's in the beginning, while you're unsure of what to do, or if you want to review a decision before making it, that you reach out to counsel to say, hey, this is what's happening, this is what's going on. I want to make sure that my decision is legally sound, right? And make sure that it's analyzed before you pull that trigger. Because once you pull that trigger, right, it's a done deal. Right. So these are some situations where you would want to call. So if there's any type of legal issue that we went through before, so harassment, discrimination, retaliation, ADA issues, medical leave issues, if maybe it involves like a high level employee, like an executive, if there's any threats of violence, any agency involvement, union issues, if there's just an employee who just, there's just multiple complaints coming through, or if there's police involvement. Okay. And so, how how my firm is going to be able to help in this situation. Everything that we discussed today is work that my firm, we help employers with every single day, right? Sometimes clients, they just simply need, a quick phone call before responding to a complaint, right? Or sometimes they need an independent workplace investigation. Okay. Sometimes they just might need a manager, maybe a manager training, because they realize that maybe this is an area that I'm not too familiar with, so I'm going to need a little bit of training here, right? But whatever the situation is, our goal is always the same. Our goal is to help employers reduce legal risk while creating fair, consistent workplace practices. That's our goal every single time. Okay. And I don't know if any of you are familiar, but if you haven't heard of the Workforce Express Training Fund, now you've heard, but I need you to go and do your research on the Workforce Express Training Fund, because Massachusetts is actually reimbursing employers up to 100% for approved training, and our firm is an approved trainer with the state of Massachusetts, and so we can come to your organizations and provide reimbursable training. So whatever employment law training you'd like to go over, whether it's leave laws, whether it's documentation, whether it's harassment, discrimination, whatever the case, we have many courses available on that state website. So if that's something that you are interested in pursuing or looking into, you can feel free to reach out to me, and we can look through to see what courses are going to be useful for your organization. All right. And who doesn't love, free money from the state? I know I do. All right. But if you are a Massachusetts employer, if you have W-2 employees and you pay towards the unemployment fund, then you would be eligible to receive up to 100% reimbursement through the state of Massachusetts for training. All right. All right. I know we are very close to time. We're basically at time, but I just wanted to make sure that I did leave time for questions. So if there are any questions, feel free. But before we go, I do want to just leave us with this one thought. Every organization is going to receive an employee complaint, right? That's not a sign that something is wrong. Like I said, it's part of leading people, right? So the organizations that, consistently avoid legal trouble, they're not the ones with the fewest complaints. They're the ones with the most consistent response processes, right? So I do hope that the Respond framework at least gave you a practical roadmap, so that the next time a difficult employee lands in your inbox, you'll know what to do, or at least you'll have Respond in mind, and you at least know where to start in handling that complaint. All right, so let's go ahead and I'm going to just check if I can figure out how to do that. Okay, oopsie, definitely can't. Alrighty. I'm checking the Q&A. All right, so I'm trying to figure out how to get this Q&A going. It should be, you should be able to see that. Okay, here, actually, I saw a couple questions coming in. Okay. All right, so this first question, it says, how do you handle situations where the employee specifically asks you not to investigate because they're afraid of retaliation. I've had that matter actually happen quite a bit to where, especially if it's something that's, especially if it's something that, legal related, maybe they don't want to ruffle any feathers, or maybe they are in a smaller department and they're just worried that they're going to have to see this person every day. But that is a great question, and it does happen more than people realize. And in that moment, I would even just first, just like I said, as far as telling them thank you, just thank them for being honest, right? Thank them for just bringing it forward, right? But explain to them that you will make every effort to keep, to respect their privacy and limit the information on a need to know basis. But the organization, depending on what it is, you do have a legal obligation to act. Once they bring that information to you, whether they want that information out or not, you have a legal obligation to act. All right. So, for instance, if someone reports maybe sexual harassment or workplace violence, you not only do you have a duty to investigate that, even if the employee tells you not to, but there may even be other steps you have to take, right? If there was violence or if this was happening, you may have to put people out on leave on pending investigation. Right. So, you can't just turn a blind eye, because guess what happens? If this turns into a legal claim, they're going to ask, oh, why didn't you investigate? The employee told me not to. Well, you still had an obligation. And so now you're facing a bunch of random fines that you didn't have to face if only you just investigated in the first place. But that conversation with the employee, actually, now that I think about it, that conversation with the employee is also an opportunity to explain the organization's, well, your organization should have an anti-retaliation policy. If you don't, you need to get one. You need to have it added to that handbook like yesterday. Okay. But you want to make sure that you're explaining your anti-retaliation policy, and just let them know that there is a zero tolerance for retaliation. And if at any point they believe they're being retaliated against, they need to come and tell you. Right. So that's how you let them know, like, hey, you told me this. I have to investigate. I'll keep it on a need to know. I won't tell the whole world. I'll just tell those who need to know, or I'll involve as few people as I need to. But if at any point this does come back and the retaliation you fear does occur, I need to know immediately so that I can take immediate action. Right. So it's almost like a delicate balance between, respecting the employee's wishes and then also fulfilling your legal responsibilities as an employer. Okay. So I hope that helped. Let me see if there's any other questions. Okay. Okay. This person said, all right, what if the complaint turns out to be completely false? Can the employee be disciplined for making false claims? That's a good one. So I think it depends, because what if the employee made the complaint in good faith? What if they didn't mean to, maybe they brought it because they really believe that that's what happened, right? And maybe after looking through there just wasn't enough evidence to prove it. Right? Maybe they didn't bring it up because they were trying to get anyone in trouble and it wasn't malicious, but after investigating, we realized whatever you said was not what happened, right? You're not going to discipline someone for that. It was an honest mistake. They brought it in good faith. However, let's say now we discover that the employee who brought the complaint forward did it maliciously, right? And they were being deceptive and they lied through investigations and all of the things, right? One thing in an investigation is we require that you are honest, right? We require your cooperation, require that you are honest. So that is a workplace concern, and that is something that can lead to discipline. But you need to be sure, you better be sure that you can prove that this person was being deceptive and that this person was being malicious. Because if you can't prove it, it's not going to be worth it as far as adding discipline. Because if this is something that can come back and bite you, and you're not able to show that they were being malicious or that they were being deceptive, it's only going to hurt you. So if you do want to take that route, make sure that you are 110% sure that this person was being deceptive before issuing them discipline for being deceptive. or at least be able to show some type of evidence to be like, okay, well, you sent this email and I have these witnesses saying that you came and spoke to them and we're like, oh, haha, I got him in trouble and he didn't even do it. Okay, now we're cooking. Now we have something to go off of. Right. So, but that was a good one because I do, that is something that I have seen before. Um, but you just want to make sure that even after that, that you're encouraging the employees that if they're making future complaints, that they're reporting legitimate concerns in the future. Right. So, um, I'm looking through. Okay, I think I'll have time for just one more because I know we're kind of over time. Um, so I'll just maybe just do one more. Mhm. All right. How do you handle anonymous complaints? Are they even worth investigating? Okay. So you should be handling all complaints. Any complaint that comes through, you should be reviewing and handling. And a complaint being anonymous doesn't make it fake. It doesn't make it less credible than a complaint with somebody's name on it. Right. So if this complaint, if it gives enough information, like if it lists names and witnesses, dates, the facts of what happened and all the things, and it's enough to at least ask questions, you definitely should be investigating, right? So don't look at a complaint and say, oh, well, because it's anonymous, I don't have to investigate it. You actually do, especially if it's a credible complaint. I know some organizations that actually have the option to be anonymous because they want to encourage employees to come forward because they realized that employees weren't coming forward because they were scared. So they're like, all right, well, you don't have to leave your name. Just fill this out anonymously. Tell me what happened. Right. But I don't want to pretend like there haven't been instances where anonymous complaints have been false. Right. But that's where you, as the investigator, should be able to determine whether something is credible or whether it's not. And you'll only know that if you ask the right questions. So if the complaint has enough names and dates and information, you should be pursuing it. If there's no information in the complaint and there's no names listed, maybe not even a department listed, it's just like, well, this person said this to this person and there's no names or dates or anything. Well, you can't really do anything with that because there's not enough information. If there's a way to reach back out to the anonymous person through, maybe if it's like a portal you're using or something and you're able to communicate through that anonymous portal, you can let them know like, hey, I really am trying to look into your complaint, but unfortunately there's not enough information. Are you able to provide additional information so that I can review this appropriately? Right. But if it was maybe a letter slipped under the door and there's nothing for you to go off of, then there's nothing for you to go off of. Maybe you just document that I received this complaint on this day. There was no information or anything involved, so I was unable to investigate further. And there was no contact information for me to reach out to anybody. At least you know that that's documented. So if it does come back some way, somehow later, you can show what you did with that complaint. All right. I know there's a couple more, but what I think I'll do, I'm so sorry, we are out of time. We're way over time. So what I'll do is I can always, send, I think there's a couple more, but if you can just email me your questions and I can always just respond via email and make sure that you guys have the answers that you need. Okay. Because I know some of y'all have to get back to work. So but I do want to just, make sure that you have my information so that we can connect. Here's my information here. So my LinkedIn, Xena Robinson, YouTube at Xena Robinson Esquire, Instagram, Mahanium Law. If you want to check out our website, it's www.mahaniumlaw.com. And if you have any questions, like I said, you can email me. That's the email that you can send it to. So if I wasn't able to get to your questions, I really do apologize. You can just email me at admin@Mahanium Law, and I'll make sure to check that inbox. I'll have those questions forwarded over to me so that I can take a look at it. Okay. And just before we go, like I mentioned, like one of the biggest mistakes that employers make is treating an employee complaint as a problem to solve. And honestly, I encourage you to treat it as information that you want to understand first. Don't just look at it as, oh, we got to solve this problem. First, like take a step back and actually try to understand what happened, right? Because the more curious you are in the beginning, then the fewer assumptions you're going to have to defend later. Okay. And, just one thing I encourage everyone to do this afternoon is really just to ask yourself, if an employee sent me a complaint at 8 a.m. tomorrow, right? Would every manager in my organization respond the same way, right? And if the answer is no, or even I'm not sure, then that's a sign that your organization might just benefit from additional training or benefit from having clearer response processes. Okay. So that's it for today. If you'd like to connect, this is how you can find me. Thank you for joining, and I hope that you all have a great afternoon.